substitute, please say aye. Aye. Opposed, same sign. Substitutes before us. A motion would be in order, or if there's a desire to hear from other witnesses, we can drop it down for a while. Let's drop it down. Okay. All right, Delegate Levine, we're ready to hear bills. So we got two bills of Delegate Levine on the agenda. First is going to be reading license. House Bill 2430. And so, Delegate Levine, as you recall, the bill reported was a close vote. I had some concerns about it. I think I expressed those to you. And because of that, I sent the bill out to some interested groups that may not have been aware of it. I got some of those groups returned with some concern. The Uber chair, Chairman Bell, did not want to usurp full committee time to hear those interested parties. So the intent, assuming the motion is made, would be to reconsider the bill, hear additional evidence, and also allow you an opportunity to advocate again for your bill, but also hear from other interest groups. So, having said that, is there a motion to reconsider that bill? The motion would be having voted on the prevailing side when we reported House Bill 2430. I move to reconsider that vote. I hear a motion from Delegate Campbell. Is there a second? There's a second. Okay. All in favor of wishing to reconsider that bill, please say aye. Aye. Please say aye. Bill before us. Okay. Do you want to hear what the opponents have to say before you?
I could. I should tell you that I have a couple line amendments that conform this bill to the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. I can make those line amendments after I hear from them or before I hear from them, but I wanted to let you know that's going to happen.
Okay. So do we have copies of what that looks like?
You don't, but they're real short.
Okay.
Should I get those to you now?
If you could, if you want to state what they are. Yes.
Sure, I'll be happy to. So if you look at the bill and you look at line,
If you're slow, really slow.
and I'll go really slow, line 69. Let me know when you're ready.
I'm pulling it up.
Okay, so the current bill says, absent a court order, a guardian should not prohibit or restrict an incapacitated person's ability to communicate and so forth. I would put between the words restrict and the words for more than 7 days. So it would read, absent a court order, a guardian shall not prohibit or restrict for more than 7 days an incapacitated person's ability to communicate and so forth. That would allow an emergency situation, the guardian to restrict it for 7 days and then move to court for a longer period. And again, that tracks what I'm going to talk about after we get from the Uniform Guardianship and Conservatorship Act. So again, it adds the words for more than 7 days after the word restrict before the word and in line 69.
Okay. Thank you.
Okay? And I have one more amendment.
Okay.
It's in line 71. Currently, it ends with whom the incapacitated person has an established relationship. I would cross out the words and established and put in place of it a family or pre-existing social. So we read with whom the incapacitated person has a family or pre-existing social relationship. Again, that tracks the uniform code language that I'm going to talk about at length after we've heard from the critics. So crosses out and established, puts in a family or pre-existing social.
Okay, thank you. Okay, so we heard from a number of people when this bill first came up who were in favor of it, but we did not hear any opposition. So anyone wishing to speak in opposition to the bill bill, please step up to the podium and tell us why you oppose the bill.
Mr. Chairman, my name is Steve Burns. I'm an elder law attorney here in Richmond. I'm not a lobbyist or a paid representative, but I am a board member of the Virginia Academy of Elder Law Attorneys. For those of you who may not be familiar, we go by VAIL. VAIL is a nonprofit organization of about 180 attorneys statewide. We focus our practice on guardianship matters, other matters related to the protection of older adults and those with special needs. I'm here to express our opposition to HB 2430. A few days ago, I circulated a letter on behalf of VAIL, which detailed our opposition. I hope each of the committee members have had an opportunity to review that letter. I think that letter provides sufficient detail as to our stance, but I do want to address a few specific issues, highlight the issues, I should say. And I'm also willing to answer any questions regarding that letter should anybody have. First,
Do you have a copy of that with you?
I do.
Okay. I'll have it in front of me.
Anybody else?
If you give us one or two, we can read it and pass it on. Yes.
I've seen it.
Okay, thank you.
Thank you. That position statement was developed after a survey of our 180 statewide members. Our members bring decades of experience dealing with all facets of guardianships, serving as counsel for petitioners, counsel for other family members, guardian ad litem, and oftentimes as guardians themselves. Our position with respect to this bill is not a reaction to one specific incident, but rather it's after consideration of the numerous circumstances that we see on a daily basis, various nuanced scenarios. This bill represents a substantial revision to the current law, and we believe it should only be made after careful consideration and input from all the various stakeholders, so we appreciate this opportunity. I understand that the genesis of the bill was related to an incident in Northern Virginia with respect to two attorneys, Ann Hushman and Ken Lapidus. I understand they've also circulated a letter to the committee members to address that specific situation. Certainly I was not part of that, I'm not a member of their firm, but I hope that each of the committee members has also had a chance to review that letter. I do have copies of it if you do not have them in front of you as well. What their letter underscores, in addition to providing some background to the scenario that may have been before this committee before, is that VAIL's position is one not just in response to one specific incident, but really it's a response to serving as guardian for hundreds of people, and that their prohibition, what they did in their circumstance, is only the second time that they've done that. I'd also like to remind the committee that guardianship proceedings are protective proceedings, so they arise out of the court of equity. It's important to remember that because the guardian is always under the jurisdiction of the court. They can always be hauled back into court if they've done something wrong. And they're always supposed to act in the best interest of their ward, the incapacitated adult. What this law does is it starts with the premise that visitation from a third party is de facto in their best interest, in the board's best interest. And that's simply not true. The bill would elevate the rights and interests of that potential wrongdoer over the rights of the court-appointed guardian. Vail believes that if this bill should pass, there's also a long-term financial cost to the Commonwealth and the public harm. Vail members, their clients, our community members fill a critical and large gap in the guardianship process. The Commonwealth, through APS or public guardians, cannot meet the needs statewide. By adding these broad stroke limitations and requirements on guardians, instead of addressing visitation or notification issues on a case-by-case basis, attorneys in the public will be discouraged from continuing to serve and volunteer their time or expertise to protect members of their community. We believe that we're nearing a crisis moment with the lack of qualified individuals to serve as guardian, and if this bill passed, we would get a little bit closer. For these reasons, and for the reasons set forth in our written statement, we oppose HB 2430. But I'd also be remiss to say, if I didn't say, that Vail strives to be a positive force in the guardianship process. And to that end, we encourage committee members and other delegates that should they have any concerns or questions about guardianship or other elder law issues, that they reach out to an elder law attorney or board member. Thank you.
Thank you. Any questions of this witness? Delegate Pope.
Can I ask you a question? If you are, in your comments addressing the amendments at all, have you had a chance to look at the amendments and whether that would change your position?
Right, so this is the first I've heard of the amendments, but no, I don't think that would change Vail's position on the bill. With respect to the 7 days, practically speaking, the code requires a 7-day notice provision for any hearing. So I don't think that really adds anything to the bill. Second, practically speaking, very difficult to get in front of a judge. Even if you are pleading that it is an emergency, Your Honor, we need to go to court. It's very difficult in many jurisdictions to get in front of a judge within any sort of short time frame like that.
How long would it take in Richmond City?
You call the court scheduler and you ask them, tell them that you have an emergency and you're at the mercy of the court. It could be 2 weeks, it could be the next day, it could be 30 days. It's really difficult to say. With respect to defining the relationships, I'm actually a little more concerned if you start roping in non-family members who may have confidential relationships. This to me seems to expand the scope of who.
Delegate Pope.
When Delegate Levine presented this bill the first time, he's presented it for a few years, is that right? A few years. I haven't heard from you all. That's, I guess it's sort of a criticism that I have. I learned about your letter through one of your members, a good friend of mine who's a member of yours, and brought this to my attention. I initially voted for the bill, but when Delegate Levine presented a couple weeks ago, he presented some pretty compelling testimony from other people, more than just one party, as I recall, where this is. Have you ever met with Delegate Levine to try to solve their problems, try to work towards a solution?
No, I have not. I do understand that he has spoken to at least one or two, maybe two other members, bill members regarding this bill. We were not aware of it until, frankly, it was, I don't want to say too late, but in order to put together a thoughtful response, it required a little bit more time on our part. As far as where were we the last couple of years, I will tell you that our Vail Public Policy Committee has revived itself over the last 12 months. And we're taking steps to be more proactive in the guardianship process because we do feel that we are having expertise that is valuable to the legislature.
Thank you.
Thank you. Anyone else wish to speak to the bill?
Thank you, Mr. Chairman, members of the committee. My name is Stephen Taylor, and I am an elder law attorney in the Tidewater area. And I'm here today on behalf of the National Guardianship Association. Hopefully you all received the letter, I believe it was sent by email from our President-elect, Becky Allred, which outlined NGA's opposition to this bill. This bill is essentially about what we call in the industry the right to association. That is the right for the incapacitated person under a guardianship to associate with other individuals, family members, friends. The NGA supports right to association, but we oppose this bill and others like it that have been proposed in other states because until just a few minutes ago when we heard about this change to the bill, it failed to provide exemptions or an exception for situations where the guardian is faced with evidence of actions, whether it's physical abuse, emotional abuse, financial abuse of the incapacitated person. It would restrict the guardian's ability to immediately restrict the perpetrator of that abuse their access to the individual. Because of that restriction, we oppose the bill. The second issue that we have that has led to our opposition to the bill has to do with the sanctions and penalties provisions in this bill. The bill does provide that a court can put sanctions on the guardian if it finds that the guardian failed to or restricted somebody not in compliance with the section. And this would be in effect even with these provisions that the delegate just proposed to the bill. We don't believe that those kind of sanctions are appropriate. The vast majority of guardians serving throughout the Commonwealth are laypersons. They're individuals, they're family members, they're non-professional guardians. They may not be up on the latest changes to the law, which would include this potential change. And now we would be subjecting them to penalties and fines for not adhering to the 7 day. You have to bring this before the court within 7 days. Many of them are not going to know about that. And we think it's going to have a chilling effect on individuals' willingness to serve as guardians for incapacitated individuals. So for those reasons, the NGA opposes the bill. We do appreciate the changes proposed today, but what I would say is we have a lot of the players here in the room, the NGA, VALA, I believe the AARP is here, and I think that this would be something that we need to step back, have everybody get together, and if we're going to work towards passing some legislation, try to do something that's going to work for everyone and for these groups. I'm not in a position to change or to change the NGA's disapproval of the bill based on this proposed amendment. Although I would tell you, because of the penalties and sanctions provision, I believe that we would still oppose the bill in its current form. Thank you.
Thank you. Any other speakers?
Good afternoon, Mr. Chairman. I'm Brad Burkowski, an elder law attorney from Tidewater, Virginia. In my practice, I ran this morning. I've handled over 300 guardianship and conservatorships. It's all I do. They tell me I'm not smart enough to do the trust, so they stick me to the court. So I do have some experience with this. I'd first like to thank Delegate Levine, him and I, to answer a question Delegate Hood asked. We spoke at length 2 nights ago. I will say the change that he gave today was my driving factor in not backing the bill. I will tell you, I had all these prepared remarks how dangerous it was for the 7-day window. So I appreciate that. And what I can say is all the stakeholders are here. I think the proponents of the bill actually want the same thing as the people who are against the bill. to association. We recognize its importance. We recognize that we could do better as a Commonwealth pushing the right to association. And again, I think my fear now is we've taken parts of the Uniform Code and not adopted the Uniform Code. I think last time I checked, Uniform Guardianship and Protective Proceedings Act is 250-some pages. We've taken one page out now that deals with the right to association, but don't have the rest of it in totality. The reason I haven't changed my stance of asking the committee to not approve this bill is, quite frankly, I don't know how the new amendments play into the totality of the bill. I think a guardianship or conservatorship over an incapacitated person is the optional last resort. It's something that's gone wrong to have one anyway. We are now tinkering with the protections and the shields of that incapacitated person. And quite frankly, while I like the change at its base, I think it's a good faith and needed change. I don't know how that plays into the rest of the current Virginia Code section, which it doesn't track the Uniform Code. I don't know how it tracks the Uniform Code, and I'm hopeful this committee would, I'll say, disapprove the bill even with the concession, but that we can all work together. Again, I think all the stakeholders agree, in theory, to the right to the association. I'm just fearful of the unintended consequences of passing the bill as is. I'm more than able to answer any questions.
Okay, all right, maybe stand by and see what, are there any questions by the committee? No questions by the committee, Delegate Williams.
I do believe that Madam ARP is here. And meanwhile, I'd like to pass out some information I have from the Uniform Law Commission, which we completely agree with the way I've done this. So, including the National Guardianship, actually, we endorse it. But that's different.
Go ahead.
Mr. Chair, David DiBiase from ARP Virginia. Appreciate the delegates' hard work on this. We all want the same thing as you said previously. ARP was concerned about having the 7 days in there. ARP was also concerned about not taking a more holistic view by taking the Uniform Guardian Act. His change of 7 days makes us neutral. I did want to just mention before stepping down that there is a new working group that you may not be aware of. It's called Working Interdisciplinary Network of Guardianship Stakeholders. They've been in existence for about 14 months.
Are they active in Virginia?
They are. It is the Virginia way. It's a national movement. It brings the courts together with the guardians, all stakeholders. They do have a bill for the General Assembly. It's to, I lost the number as I came in here. But they are active in Virginia. They want to be more active. They want to work with Delegate Levine. And we hope that as we move forward, it is with all stakeholders. No disrespect to the delegate. We weren't here last year. We weren't here the year before.
Question, Delegate Williams.
Yes, and I'd like to go through my packet.
Yeah, I understand. And this may be a rhetorical question, but I know you've brought this for several years, and many legislators get to the point where they feel like they're banging their head over against the brick wall and don't want to lose any time. What are your thoughts on having this studied in the off year?
Well, if the bill doesn't succeed, obviously that's where I'll go. But I'd like to make an argument because the bill should have it this year.
Understood. Go ahead.
All right, so what I passed out to you is from the Uniform Law Commission. According to the Uniform Law Commission, this is a terrible problem across the entire United States. These guardians holding wards in isolation. They believe it is such a tremendous problem that they developed this uniform codes all across the United States. And I should note the people who created this, and it's right at the bottom of that first page, are AARP, Alzheimer's Association, National Guardianship Association, the National Center for State Courts, the National College of Probate Judges, the ARC, the ABA Commission on Law and Aging, the National Academy of Elder Law Attorneys, and the National Disability Rights Network. And all of them agree the way I've done it in this bill as amended is exactly the way they would do it. Now, it's true, and we're going to get to this, that it's one page out of a 257-page Uniform Act. It is true that I have not presented the whole 257 pages to you. It's my belief in this body, as actually I heard Delegate Miron say at a committee before me, that it's easier to work narrow than broad, and that it is easier to talk about a half page of code than 257 pages of code. I want to talk about why the belief of the Uniform Law Commission and all these groups, including, by the way, National Guardianship Association, AARP, Alzheimer's, all these groups down below, is that people should have the right to see their loved ones. This is about the incapacitated person. It's not about the guardians. It's not about how they get their attorney's fees. They're right that my bill would say if you act in bad faith, the court can charge them fees. But I don't know why anyone would defend the right to act in bad faith. I think the right to act in bad faith is not a right. So that's the fees where they can be charged. And yep, if people act in bad faith, I'm not sympathetic. But let me go through what the Uniform Law Commission has said about this. The heart of it, and I put a little asterisk by it, is that UCGOPAA, which is the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, helps prevent isolation. Quote, a guardian may not restrict family members and friends from visiting or communicating with a person subject to the guardianship for more than 1 week without a court order. That's what all these bright minds, professors, and lawyers nationally have come up with. And remember the three people. Yolanda couldn't see her sister until she died. Max Carlatos could not see his father for several years until she died. Currently, right now, Mike Jacobs cannot see Jane Lopez, who I remind you gave him a power of attorney. She said, you're the person to take care of me if anything happens to me. And he hasn't seen her in a year and a half, despite the fact that she begs him, and I played the tapes. She says, I want to see you now. You're the only love of my life. And I'm going to fire that damn attorney. Well, unfortunately, she has no power to fire her attorney because her guardian, in effect, owns her. He has complete control over her. When you say that someone can be hauled back into court, she has no power to haul him back into court. She's mentally incapacitated. I'm going to, actually, we'll go right to that point. It's on the last page of this whole packet. This is a quote from Jane Lopez, the last quote Mike Jacobs ever heard on a voicemail November 24, 2017. So it's been a year and a few months. She writes, as soon as I get my hands on my lawyer, she didn't write it, she said that I can play the tape, you've heard it. As soon as I get my hands on my lawyer, I'm going to find out exactly where you're located since I don't know where the hell you are, and he's going to give me the damn full information or he's fired out of my life forever. But she can't fire him. This may be the only person who can't fire an attorney. Even a child who has an attorney grows up and can eventually fire him. So what UGOCOPAA does is it recognizes that it's the autonomy of the incapacitated person that they're trying to protect. If you go to the next page, they say that the major objective is to stop abuse or exploitation by those entrusted as their guardians. That's why this is here. And it provides stronger, more effective oversight and enforcement by giving, and again, it says down below, eyes and ears for other individuals to be noticed so family members can see if there's abuse. And I remind you what happened with Matt Scarlatos, right? He saw his father for years. Then what did he do? He complained about abuse. He said there are bruises up and down his father's side. The guardian did nothing. So he complained again. The bruises were getting worse. Please stop physically beating up my father. At which point the guardian immediately said, you can't see your father. And then he spent $250,000 fighting that guardian. When family members have to sue for access, they're using up their money, but the guardians get to take money from the ward, which actually is the estate money that family members get. They lose both ways. And the guardians do really well because they could say, you come after me, you want to see your father, it's going to cost you. Remember, they wanted to charge Matt Scarlatos $5,000 a visit until his father died, until they could see him. Matt Scarlatos was so angry that he wanted to come down here because he was afraid he was going to curse out all of it. So that's why he's coming. But let me read on what it says. UGCOPAA says the guardian must consider the individual's needs as well as the individual's preferences, values, and prior direction. Well, Jane Lopez, we know what she wants. She wants to see Mike Jacobs. She said so 4 times. She's begging him. We know that she signed a power of attorneys. Let her see him. And we know that Mike Jacobs would give no reason why he can't see her. Again, it talks about the self-determination of individuals. giving the individual the right to participate in their own decisions. And it says that they must make the decision the adult would make if able, unless doing so would cause the adult harm. This includes decisions about association with other persons, all in the Uniform Law Commission Act. And then on the back, the next page, again, under UGCOPAA, court approval is required for a guardian or conservator to restrict visitation with a family member or friend for more than 7 days. It goes on to say it raises unnecessary fees. One of the things this does is if you oppose a guardian and you want him removed, he can't get fees fighting to stay. In other words, you say this guardian is abusive, I want him gone. He said, bring it on, I get paid either way. You know, I want to see my dad. You want to see your dad? I get paid to stop you. I don't get paid to support you. I get paid to stop you. So I understand this is lucrative for a lot of guardians. Again, all the national organizations that support this, ARP, American Bar Association, ARC, American College of Trust and State Council, National Academy of Elder Law Attorneys, the National Association to Stop Guardianship Abuse, National College of Probate Judges, the National Center for State Courts, National Disability Rights Network, and yes, the National Guardian Association have all come down in support of the whole 235 pages, which includes this one page, yes, on visitation. Again, if you go to the next page, it goes on to say, a guardian should be required to make decisions that they believe the adult would make. And finally, on the next to last page, I have the actual page from this act, which is 136 pages on my computer. If you go to page 58, you can see that the Model Act, this is Section C, basically does what I put in the Virginia Code and says you can't restrict the ability to communicate, visit, or interact with others unless authorized by a court, and then you have to argue that there's some significant damage. And for not more than 7 business days, I can make a business if that's the issue, if the person has a family or pre-existing social relationship. One of the criticisms I've heard, and I did, just so you know, I never heard from Viola at all. I didn't know about this letter until one of you folks told me about it, and I got a copy of the letter. I did talk to this gentleman right here. We talked for, what, an hour and a half? 2 nights ago, the first I heard of the problem. And I tried to put in his concerns, which is why I changed not just the 7 days, but also redefined. Now, established relationship was in the code, but I agreed with him that it needed a better definition. So I took the definition that all these very smart people came up with, which is family or pre-existing social relationship. So I would argue that what I've done here is exactly what all these great minds have done. It's true I haven't put in all 200 odd pages. But this principle is very, very clear. I mean, you look at what they write, they mention it again and again and again. There's only like 3 fact sheets, and they mention this is critical to the bill. Let me see if there's anything else. They can't be hauled back into court because no one's watching this. By the way, I talked with my local courts. I talked with the guardian ad litem, and they said, well, we don't take this case. Because we don't take it unless someone brings us in. Well, Mike Jacobs, I asked him, why did you bring it in? He said, because the guardian threatened me. He said, I'm going to bankrupt you. I'm going to take all your money. You'll never be able to do this. And I'm going to take Jay Lopez's money, too, in fighting. So he didn't want to harm her. He didn't go back into court. But they're supposed to act in the best interest of the incapacitated person, not their own bottom line. I mean, this guy has 300 guardians. My guy in Alexandria has more than 100 wards. It's very hard for someone to watch over 300 people. In Alexandria, I can't speak for the gentleman behind me, they have people watch these people. It's not like the guardian is, I mean, these are professional guardian mills. I should say this, don't worry about the public guardian. We exempted them early on. We don't know about that. If they really don't like someone, they can put the restriction in the initial order when you're first appointed. Ne'er-do-well son's a bad dude. We're going to bring it up right when we get appointed in the first place. You get that out of the way, then you don't have to worry about it. That's allowed. I mentioned that the penalties can only be for bad faith. And lastly, I would actually like to play, if I could, it only take 20 seconds. The Uniform Law Commission has put out a little 4-minute primer on why they think this is so important. And I want to play just 20 seconds from what they put out on the web about why they consider this so important. If I could ask Jake to do that. Can it be heard?
We should each say to ourselves, would we want to be deprived of all our liberty? Would we want someone else making all of our decisions for us? I think
very simplistic terms, is to be able to give people who needed assistance the ability to keep their dignity.
Okay, stop it. So, again, and I can play for you, I guess I should end with Jane Lopez. Because she's trying to have a little bit of dignity. She's trying to see her love. She doesn't understand why she's been kept away. He doesn't understand why he's been kept away. But the system keeps them away. So I guess I just want to end with the last words Mike Jacobs ever heard from Jane Lopez on November 24, 2017. It started at 55.
Michael, I love only man I ever loved, as you well know. As you said just a while back, we're not going to be able to find each other at some point. You can choose to on that basis. That's only I got choose on that basis. Otherwise, I will be searching for you, looking for you, and as soon as I get my hands on that lawyer, I'm going to find out exactly where you're located. Since I don't know where the hell you are. And he's going to give you the damn full information or his fires, like forever. Okay. Well, each and I want. Peace. One.
Okay. So the goal of these guardian bills, and this is exactly what the Uniform Law Commission is saying, is the guardian should be acting in the best interest of their ward. Jane Lopez should be in charge to the extent that she's mentally able. And to the extent that she's not, she should be able to have the people that she trusted, she signed a power of attorney over to. By the way, that's actually also in the Guardian Act, that people they signed a power of attorney over to. But I think pre-existing social relationship would count. She wants the people that she trusted, that she loves, to see her. And the fact that guardians are profiting of keeping loving people away from each other, from people who are taking care of Alzheimer's patients, I have to say I find offensive. I really do. I think that guardians should look out for their wards. And again, if there's a real problem, they can move. If it's 7 days, if this body wants to make it 14 days, that's not the issue. Mike Jacobs has waited 15 months. He can wait 14 more days. But at the end of the day, people should have a right to see their loved ones. The vast majority of people who want to see their loved ones are not abused. The vast majority of people who want to see people with Alzheimer's are not out to get them. This isn't about money. That's not a conservatorship. That's a completely different section of the code. There may be problems with that other 200 pages of the bill. I don't want
We
to
really need to wrap this up.
All right. I made my points.
I have one or two questions.
Yes, please. Yes.
Do you know the recording that you played? Do
Yes.
you know whether that statement was made before or after she had been declared incapable of handling her own affairs?
That one would have been November, so that one would have been after.
After. Okay. After she had been declared unable to manage her own affairs and make decisions for herself.
Before she signed the power of attorney before.
Do you know the name of the guardian that was appointed to represent her?
Yes.
What was her name?
His name's Tim Humphrey.
Okay. Is he associated with Ann Eisman?
Yes, I should tell you this, just to be fully honest with this committee. I called Tim Humphrey in September, and I said to him, you know, I'm a delegate, Mark Levine, I never met the man in my life. I said, I'm calling, I want to find out what's the deal with Mike Jacobs. Within 60 seconds, he used the F word several times, told me to effing get out of his business. It was none of my effing business. And within 90 seconds, he hung up on me. I will tell you this, I have practiced law since 1992. I have never had a lawyer speak to me that way, and I told him I was a delegate. So I asked some other people about this guy, and they said, well, he makes a lot of money off these things. He makes millions of dollars on intervening with his livelihood. But he's never explained to me why he would, I mean, I can handle cursing, being cursed out. But I was really surprised to hear that level of unprofessionalism from someone who has more than 100 words and apparently some 90% of the business in Alabama. So just full disclosure.
Thank you. I think Delegate Campbell had a question of
Yes.
some of the elder law attorneys.
Okay.
It doesn't matter whichever guy, any of you guys can probably answer this. Best of my recollection, and I'm going to show my age a little bit here, the last time guardianship and conservatorship law in Virginia was substantively changed was about 18 or 20 years ago. Is that right?
Yes, sir, we've done the Uniform Act, I'm sorry, let me be clear, the Uniform State Act, meaning it's now easier to transfer back and forth, but yes, you're correct.
prior to that, law in Virginia had been settled for 3 or 4 decades, is the best of my recollection. Is that also accurate?
I would assume so, still in elementary school.
Fair to say that this type of law does not change very often in Virginia?
Yes, sir.
So, is it also fair to say that these laws vary wildly on some occasions from state to state as well?
Not so much anymore. I think there are a couple. First, just for the record, I am not the guardian conservator of 300 people. I would be driven to incapacity if that was the case. I have petitioned for over 300 people. To answer your question, is we are becoming more in line with the state. Other states, everybody is moving kind of piecemeal towards this uniform act. Some, I will say, I've never seen the restrictions and protections piecemeal in. I am in the National Guardianship Association we attend. And I think, going to that point, this is the issue that's coming up is Delegate Levine correctly stated the Uniform Act, but that's also in our act. I'm looking at it right now. We shall take into consideration the personal desires of a ward. It's a shall, it's not a may. So again, my fear is we are not out of line, if that was the question. We are very much in line. We're not an abnormality, but it's this refrigerator magnet approach that I think is dangerous.
Is it also fair to say that today's society, even incapacitated persons, are far more mobile than they were, say, 20 years ago?
Absolutely, far more mobile. The technology allows them to communicate with both good and bad doers.
And they're moving in some occasions from state to state, and so enforceability of these orders becomes an issue, does it not?
Yes, sir.
And so is that the reason also why the Uniform Law Commission developed the UGCOPAA as well?
Yes, sir.
And hopes that there would be smoother enforceability, people moving from state to state?
Yeah, smoother transfer so the process doesn't have to be restarted.
Last question. If this bill if it's carried over a table, whatever the case may be, will you avow to work with Delegate Levine in the off-season to try to?
I would enjoy the opportunity. I'll tell you, all the stakeholders I'll speak for them would like to do that, and I think we've developed a good working relationship over the hour and a half we've talked. I would enjoy that opportunity.
Thank you, sir.
Yes, sir.
Delegate, is that an old?
Well, it's on the same lines as Delegate Campbell. I think Delegate Levine has presented some pretty compelling testimony describing there's a problem that needs to be solved. You guys are coming here representing that you don't think that solves the problem. And I think that we have to address this issue.
I would agree with you. And by the way, I want to be clear, I think it does solve the problem. To me, though, it creates a bigger problem. It strips the protection of being incapacitated, which is what the guardianship statute's for. I gave a stupid analogy to my law partner that it's like a flight attendant comes to the pilot and says everybody's air sick. So I said, oh, let's crash the plane. I mean, you cure the air sickness, but you kill everybody. I think stripping the right to ban a evildoer while allowing the right to association, again, we're all for the right to association. Every group is. He correctly cited it.
Just you know that you have the right to stand an evildoer in my bill. You know that, right? It's the very first part of the bill. I just want to be clear.
Please ask some questions.
I think we should just keep it up here for now. I mean, Delegate Levine presented some compelling testimony, and so I voted for it in the subcommittee. Listening to you all, I've told the Patriot that I cannot vote for the bill going forward. And what I would like to see happen, Mr. Chairman, is I would like to turn this bill into not a study bill, but to require all these groups, even those that the patron cited in this Uniform Law Commission code, of the Virginia version of these guys to all come together and report back to the General Assembly on this topic. And so that would be what I would like to move to change the bill. And I know we sometimes work in concepts here, but I do think that Delegate Levine has brought an issue to us, a problem that needs to be solved. I think we've got other parties here that are willing to work together to do this. We do this frequently where we ask other people to get together and work something out. And so that would be my motion.
So is that a motion to pass the bill by for the day?
Well, I don't know, that might be, we don't have time to do that, do we?
Well, we don't, but it's different than laying it on the table. I don't know that it really matters to me how we handle it. We're not gonna report it, but I'm trying to be.
Can we do a section one, require them to meet with me in good faith?
Well, so this is what I'm willing to do, and that is, to the extent anybody listens to the subcommittee chair, to write a letter to the Bar Association, the Elder Law Section of the Bar Association, asking them to take the lead on this. I believe, maybe, I could be thinking of another bill, but I think OSC may be interested in it too. And to the extent that I can write that letter that matters, I will do so. I will also appeal upon the Uber chair, Chairman Bell, do that as well, and in that letter, ask them to include in that effort. I think we kind of want an official state body responsible for it, because they're accountable to us.
That would be good.
The outside groups are not accountable to us, so we can find a group that's accountable to us to include these groups to study it, and that would be, I think, a good way to proceed. And I agree with both sides, and it's a difficult call to make. I know I had a bill several years ago that dealt with a uniform commercial code matter, and it took several years to get Virginia's version ready for prime time. But when it came, it was a good piece of legislation. Hopefully we'll do the same with this.
I would hope, Mr. Chairman, that if there are concerns about some of the 200 other pages of the Uniform Act, that won't mean that we can't help people like the people I'd very much like to help, because if we wait for the one good page, for the other 200 pages, which I admit I have not studied, we may be waiting a number of years. So I hope it is the message of this committee to these gentlemen over here who, again, never contacted me until a couple days ago. Actually, they didn't contact me, I contacted them. That if they don't work with me and we don't get anything accomplished, that hopefully we'll be able to go forward next year. Because I think without that sort of Damocles, so to speak, they have no incentive to actually work with me to come up with a really good line.
They're on the same page. So,
All right.
a motion would be in order. Second.
Second.
All right, there's a motion and a second to gently lay the bill on the table. All those in favor or opposed, please record your vote on the board. That motion carries on a vote of 7-0. Kelly Levine, I believe you're.
Here we go again.
Well, we're gonna have Delegate Sullivan come on.
Fair enough.
He's, I think.
I have a